In the heat of the civil rights movement, many activists were risking their safety and freedoms by taking a firm stance against the oppressive forces that wanted to uphold segregation. Martin Luther King Jr. was among the most important and notable in his day. With his fame came targeted attacks and harassment in many forms.
One instance of an attack was a legal claim that MLK was guilty of perjury based on accusations of lies he allegedly told on a Montgomery resident's tax-related document. He was convicted in Alabama and received a suspended sentence and a fine. However, many historians view this prosecution as politically motivated and part of a larger effort to harass civil rights leaders.
The Committee to Defend MLK and the Struggle to Defend Freedom in the South wanted to find a way to support MLK during this time. They decided that an ad in the newspaper to raise funds for MLK's appeal was a good solution. They acquired several signatures from fellow activists and famous people of the day.
L.B. Sullivan was the public safety commissioner in Alabama and thought this ad was an attack on both himself and his fellow police officers. This leads us to... Welcome to New York Times vs. Sullivan.
I'm Tyler Schrank.
And I'm Cameron Banks. In 1964, a group of people filed a full-page ad in the New York Times to defend MLK on his perjury charges. This ad contains several inaccuracies.
Sullivan asked the New York Times to publicly retract the information because he felt that it was libel and looked bad on him and his subordinates.
The New York Times refused and claimed that they were puzzled by the request.
Sullivan sued the New York Times for libel, which puts us in the Alabama trial court. This brings us to the first of 3 stages for this court case. Now, some facts in the ad were inaccurate, like the number of police officers or the reason why some students were kicked out of school. And even though Sullivan wasn't named in the ad, the judge ruled in favor of Sullivan, saying that the statements were libel per se, and Sullivan won $500,000 in Alabama state court. This brings us to stage 2, the Alabama Supreme Court. The New York Times appealed the previous decision. However, the Alabama Supreme Court held that the ad was still defamatory and that criticism of government officials was not protected by First Amendment rights. Then, New York Times petitioned one more time for certiorari, and the Supreme Court granted the review. This brings us to the third stage, the U.S. Supreme Court. Sullivan thought this was going to be open and shut. He had already won it twice before. Nothing wrong with that, right? But the New York Times thought there was a bigger issue at hand. They thought that if the Supreme Court upheld previous decisions, that they would limit free speech for press, and that any press would be terrified to post anything, because if they ever happened to accidentally post anything false, they would be sued into oblivion. Now, Supreme Court agreed with the New York Times. They reversed the Alabama Supreme Court ruling, and they said that debate on public issues must be uninhibited, robust, and wide open. And public officials can't recover damages for defamation unless they prove actual malice.
The core media law issue of this case was the Supreme Court had to decide if the First Amendment could protect defamatory false statements about public officials. They had to decide if Alabama's libel law was restricting freedom of press or freedom of speech. Alabama at the time was operating under a libel per se, which means that falsity and malice could be presumed without any proof. This was really bad because public debate will always include some factual errors. People will make mistakes, people will go too far and say things that might be untrue, but the government can't just assume any time that you are operating under malice, because this would shackle the First Amendment and would make the public too scared to speak out. The Supreme Court unanimously reversed the previous ruling and announced a major First Amendment rule. The Supreme Court said, a state cannot award damages to a public official for defamatory statements unless the official proves actual malice. And there is a sufficient lack of evidence to prove that the New York Times did act with actual malice. So the Supreme Court noted that the newspaper had no reason to believe the ad was false because they went through their proper procedures for accepting the political advertisement.
The legal test that was established by this case was actual malice. This means public officials must prove the statement was made with knowledge of its falsity and reckless disregard of the truth. And the proof for this must be very clear and very convincing. In New York Times vs. Sullivan, the courts didn't find this. They said the New York Times didn't know the statements were false and they didn't act out of reckless disregard for the truth. So, they were good.
A couple of major takeaways that came from this court case. The first one being it set the modern standard that protects robust reporting on public officials. It also said that political paid advertisements are protected speech, so that way media outlets that accept payments for these ads don't have to be afraid of losing those First Amendment rights. The next one being public officials cannot silence criticism by relying on local state laws that presume malice without proof, like Alabama. And the next major court case that actually used NYT versus Sullivan as a precedent was Curtis Publishing Co. versus Butts, which extended the actual malice rule to all public figures, not just officials. Let's do a quick recap.
The New York Times posts an ad in support of MLK, and Sullivan sues for libel. He wins in Alabama State Court, $500,000. It goes to the U.S. Supreme Court, and he loses.
Alabama's law relied on libel per se, which means that falsity and malice were presumed without proof. This is really scary because that means the general public can make any type of statement criticizing an official, and the government can just assume that you were acting with malice.
The court held that states cannot give damages to public officials for defamatory statements unless those statements were proven to be made with actual malice.
The definition of actual malice means that the speaker must have known that the statements were false or acted with reckless disregard to the truth. In our case, it was found that the New York Times did not do this.
There are two main takeaways from this case. Firstly, public officials who want to silence criticism can't just rely on state laws. Also, paid political ads are protected speech under the First Amendment. Thanks for watching.
We hope you learned something. Bye!